Hello, everybody. It's Debbie Keither here with you today for Deliberate Indifference. I'm going to go through a couple of motions that have been received as of late within the last week or so. Some of them are related to my case, and others are related to different MPS cases. And I want to say that I have permission from all of the individuals who are the plaintiffs or the complainants in the matters. And also for my own case, I get everything off of Pacer. So Pacer, Case Locator, I pay for all of those documents, and so I have them accessible to me in a moment's notice. So they are available there, and that's where I get them from. So I'm going to share a couple of these with you, and let's just take a look at this one because they have a common theme. And the common theme is obsession with YouTube. So let's go ahead and take a look at these. This one is an affidavit of Lori McElroy in support of the motion to prohibit video recording of the contested case hearing. So here is one of the attorneys for the respondent, Milwaukee Board of School Directors, and she is making an affidavit to prohibit video recording. Okay, now these are equal rights division cases, and they are employment cases, this particular one that I'm reading. So here she states the depositions of Robert Peterson, Aisha Carr, and Marva Herndon were conducted in this matter on October 7th, 2023 and January 5th, 2024. She has reviewed the YouTube channel Deliberate Indifference Wisconsin, and it appears that either Attorney Hitchcock Cross or Deborah Keither has posted 10 videos of the deposition of Robert Peterson, 14 videos of the deposition of Aisha Carr. She should go back and look at those carefully. And 8 videos of the deposition of Marva Herndon to this said YouTube channel. Most of it, if not all of these videos, contain demeaning and incendiary titles and thumbnail art accusing the deponents and their attorneys of misconduct and poor performance and ineptitude. Wow, she sure gets a lot out of those titles. A few examples of the thumbnail screenshots of these videos taken on December 5th, 2024 are as follows. So you can see those here. Taxpayer money equals superintendent raises. Board members know, they just don't remember. Everything is obscure in my mind, in quotes. Opposing counsel can't take the heat, rage quits. Either Attorney Hitchcock Cross or Deborah Keither has also continuously posted videos accusing the Wisconsin Department of Workforce Development of misconduct in this matter, including as recently as December 4th, 2024, a video titled Administrative Agency Contracts Away Bias. A link to the video can be found here. So attached here too, as Exhibit A, is a true and correct copy of a March 25th, 2024 order. Now look at the date of that, March 25th, 2024, and depositions were taken in October of 2023 and January 5th of 2024. So this order that she's referencing has come well after the fact of all of these things. But she attaches an exhibit showing this pre-hearing order, an ethics opinion, and the motion to preclude audio or video recording. So she's got all of that in there. And again, note the date of this. These are all things that take place after the actual depositions occur. So I'm not going to page through all this because it's several more pages. I mean, I could, but it's kind of a moot point because this order came after all of that stuff occurred. So, I mean, you can't go back and, try to put something in place for something that's already transpired, an order. So we've got some of these pieces. I can go over this. I more so just wanted to go over some of the motions about the YouTube. And if people want to hear this, we can. There's lots of documents filed in this. So now I'm going to go in here. Here's the, oh, this was one of the exhibits. So I've got it kind of pulled out here. She this is the actual motion. So let's go into the analysis. Complainant has taken 3 videotaped depositions of respondents' administrative officials in this matter. She lists them: Robert Peterson, October 17th, 2023, Aisha Carr on January 5th, 2024, and Marva Hernan on January 5th, 2024. Either Attorney Hitchcock Cross or Deborah Keither has posted 10 videos of the deposition of Robert Peterson, 14 videos of the deposition of Aisha Carr, and 8 videos of the deposition of Marva Hernan. So this pretty much is a repeat of what's in her affidavit. She talks again, here's the same thing, saying that these titles are accusing their attorneys of misconduct, poor performance, and ineptitude. So there she grabbed a few that she thinks show that. Actually, yes, this is almost exactly the same as her affidavit. On March 25th, 2024, again, after all this already happened, creating unofficial audios or videos of depositions and then using them on social media along with commentary creates a risk, perhaps substantial, of witness intimidation and harassment. So that's what they are saying. Going forward, any and all audio or video recordings of depositions shall comply in all respects with the requirements of Wisconsin Statute 804 to 885. All of the depositions did fall under they were noticed and they were properly by a licensed court reporter was there with a transcript, and no official use of those videos. We have not entered them into any record, so I'm not sure what they're talking about. So she goes into the administrative law judges have the authority to regulate the course of the hearing, which I guess means you can't record anything. That's like the ALJ and the ERD's big thing, nothing recorded. He has, Ben Hitchcock Cross has confirmed at the pre-hearing conference in this matter that he plans on videotaping the contested hearings so that he can replay it on a show that he produces and broadcasts on a YouTube channel. So she's calling this witness intimidation and harassment. So these public officials, as she admits that they are board members, some are public elected officials. Most of them are all of them work for the public school district, the largest one in the state of Wisconsin. And she really just thinks that it's inappropriate for these people to be subject to public scrutiny. Prohibiting video recording of the merits hearing will not prejudice the rights of the complainant. Okay. Further, in a recent Wisconsin formal ethics opinion, the Wisconsin Ethics Committee addressed the issue of recording administrative proceedings without the consent of the tribunal directly. The committee recommends the same approach for hearings conducted by administrative law judges. While they are not judges in Wisconsin, the Wisconsin Administrative Code acknowledges their authority to regulate hearings to ensure a fair process and does allow for the recording of hearings with notice and the consent of the ALJ. Recording without the knowledge and consent of the ALJ is not contemplated by the relevant rules and undercuts the tribunal's ability to control and manage the proceedings. At a minimum, surreptitious recordings of the administrating hearings and related conferences or proceedings could be seen as violating the prohibition against deceptive conduct. Well, it's not deceptive because we've said it outright that it's going to be happening. We just don't understand why they wouldn't allow it to be recorded. Okay. So this is her asking for this recently. Now I'm going to go into mine. Again, my stuff is in Pacer. So anybody who has a Pacer account can set up their account and access documents. So let's see what Lori McElroy has this time. Blah, 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 blah. The statements set forth in this declaration are made of my own personal knowledge, and if called as a witness, I could and would testify competently to the matters below. I am an attorney licensed to practice in this court and in the state of Wisconsin, and I am one of the attorneys representing the defendants. During the pendency of Deborah N. Keither versus Milwaukee Public Schools, Wisconsin Department of Workforce Development Equal Rights Division, plaintiff and her attorney took several depositions, including defendant Calvin Furman, for more than 8 hours, including breaks, on August 16th, 2022, and Felicia Saffold for more than 8 hours, including breaks, on August 8th, 2022. Attorney Hitchcock Cross maintains a channel on YouTube titled Deliberate Indifference Wisconsin. This YouTube channel is available to the public and can be accessed at this link below. As of November 25th, 2024, the Deliberate Indifference YouTube channel currently has 7,000 subscribers with 706 videos that have approximately 1.3 million views in total. Plaintiff in this matter, Deborah Keither, is the registered agent for Deliberate Indifference Wisconsin LLC. The corporate registration records are available to the public and can be accessed at, there's the link. The principal office for Deliberate Indifference Wisconsin is located at Attorney Cross's personal residence. They leave off that mine is also on there. This is very selective. The majority of videos posted on the Deliberate Indifference channel appear to pertain to cases in which Attorney Hitchcock Cross serves or served as counsel. The plaintiff frequently appears with Attorney Hitchcock Cross in videos on Deliberate Indifference channel in which she specifically discusses her pending case against the defendants. Defendant Calvin Furman has filed suit against plaintiff, Attorney Hitchcock Cross, and Cross Law Firm alleging defamation. Cross Law Firm has since been dismissed as a party to the suit. Public records of the proceedings can be found here. I have reviewed the operative complaint in the matter, which alleges that Attorney Hitchcock Cross and plaintiff defamed him in a series of videos posted to the Deliberate Indifference channel. These videos have since been removed from the Deliberate Indifference channel. Within the last week, additional videos featuring plaintiff and pertaining to Furman have been uploaded to the channel. Attorney Hitchcock Cross has also posted several clips of video recordings of the depositions of Milwaukee Public Schools administrative officials taken in this and other ERD matters, including Senior Director of the Office of Accountability and Efficiency, Matt Chasen, Board President, Marva Herndon, former Board Clerk, Jacqueline Mann. We don't have anything on Jacqueline Mann. Former Board President, Robert Peterson, Board Member Aisha Carr, and Felicia Saffold. Many of the videos include inflammatory or suggestive titles such as Milwaukee School Board President cannot articulate her duties. Board President continues to shift blame to everyone else. And board member conduct business with private email accounts, among others. Many of plaintiff and Attorney Hitchcock Cross's videos include inflammatory references to the defendants in the case, calling for their resignation or removal and accusing them and other administrative officials in MPS of various acts of wrongdoing. Several videos also accuse MPS's representative counsel of misconduct. Many of the video thumbnails contain images of both the witness and the witness's representative attorney, Attorney Chris Reardon, in a disparaging manner, such as, let's see. Okay, and these are just straight up depositions. So there's nothing like, there's no commentary in these. A video uploaded on January 30th, 2024, titled Deposition Chit Chat and BHC Remonstrates with Chris Reardon, appears to be recorded from a device different from that used by the videographer recording the deposition, as that video camera can clearly be seen in the video itself as depicted in the screenshot. Wow. That is a lot of guesswork there. Beginning at 8:52 mark in this video, Attorney Hitchcock Cross engages in an off-the-record discussion with Attorney Reardon regarding the issue of whether or not the witness was informed of specific dates in a notice of deposition. The use of additional video recording device during depositions is readily apparent in several other videos posted on Deliberate Indifference YouTube channel. Many of these videos, including the video above, are of depositions conducted at Attorney Hitchcock Cross's office. On September 23rd, 2024, undersigned counsel, Attorney McElroy, attended a hearing in the Jose Garcia Hoven versus Milwaukee Board of School Directors case, where Attorney Hitchcock Cross brought with him Mike DeGale to film the proceedings. DeGale refused to identify himself for the undersigned counsel and appeared to film undersigned counsel and her laptop screen during the hearing. My God. On November 6, 2024, I, along with co-counsel Attorney Michael Scherer and Attorney Hannah Kohlberg, had a meet and confer telephonic conference with Attorney Hitchcock Cross, wherein we discussed several issues related to this and other litigation. Attorney Hitchcock Cross indicated that he was requesting the deposition of several parties and would advise of their identities. We discussed whether we had any resolution to several requested parameters for depositions, as had been discussed in another litigation matter between plaintiff's counsel and Milwaukee Board of School Directors, for which a protective order motion had been filed, but ultimately withdrawn when the request for depositions was withdrawn. There was no change to prior positions, and we advised Attorney Hitchcock Cross we would have to file a motion for protective order, as was similarly filed in other litigation. I'm going to withhold my comments here. Attorney Hitchcock Cross has been the attorney for the plaintiff and that I and my co-counsel have been in contact with throughout the course of attempting to schedule deposition in the matter. On November 7, 2024, attorney for plaintiff Ben Hitchcock Cross contacted me to request the deposition of Jeremiah Holliday, Calvin Furman, Jacqueline Mann, Marva Herndon, Catrice Cotton, and Keith Posley. Okay, so here's the exhibits. Okay, now she's talking about discovery to them, and discovery. My co-counsel, Attorney Hannah R. Kohlberg, conducted a meet and confer with Attorney Hitchcock Cross regarding the parameters for the depositions. A true and correct copy of the letter is attached in Exhibit 4. In the letter, Attorney Kohlberg raised several concerns regarding the depositions and the parameters by which the depositions would be conducted. They're so used to dictating everything. So in my federal case, they are claiming that I can't depose a named defendant. Calvin Furman had already been deposed in the ERD proceedings, and since Jacqueline Mann was no longer a defendant, the relevance of her testimony was not immediately apparent. But she is a named defendant. She was not dropped. Subject matter limitations would need to be in place for the depositions. The depositions could not take place at cross law offices, and that no one other than the necessary parties should be in attendance, according to them. The depositions could only be recorded by a certified videographer. That's all we've ever done. The deposition videos and their transcripts must remain confidential. These are public officials. Attorney Hitchcock Cross did not respond substantially to the concerns, but rather engaged in a circular, hypothetical questioning of co-counsel. To date, Attorney Hitchcock Cross remains evasive about the value of a second deposition of Furman, the need to depose Mann, and his objections to the defendant's concerns. They just write their own whatever they want. I certify that prior to filing defendant's motion for protective order, I conferred with Attorney Hitchcock Cross, plaintiff's counsel, in an effort to resolve the issues concerning their requested depositions. But the parties were unable to come to an agreement. And she declares under penalty of perjury that the foregoing is true and correct. Dated the 2nd day of December 2024. So these are the kinds of things that are being rapid fire. Most of them are about YouTube and the fact that these individuals believe that these public officials, these public employees, whether they're elected or whether they are in the cabinet, should not be able to be recorded, and their testimony should not be recorded. I can't make sense of it. This isn't even a private matter. This is a public school district. So we just wanted to read a few of those. I mean, there are several of these. They're kind of like cut and paste all the way through with the same kind of statements. I mean, I'll limit my commenting, but let us know what you think. Does this sound right? Should I be paying for a federal lawsuit where I can't share and record, keep a record, especially when there are all of these ridiculous misrepresentations as part of the record? Why don't you just want to keep a record so that everybody can see exactly what's transpired? Why wouldn't anybody want to do that? If anyone can answer that question, I would love to know. Thanks for sticking with us.